Moratorium. Section 14 describes the effect of moratorium declared under Section 13 of the Code. Section 14 reads as follows. Subject to provision on the insolvency commencement date, the adjudicating authority shall by order declare moratorium for the prohibiting all or any of the following acts. So, first, institution of the suits or continuation of the pending suits or proceedings against the corporate debtor, including execution of any judgment, decree or order in any court of the law, tribunal, arbitration panel or other. And the exception to this clause is criminal cases. Company can file and even others can also file against the company. And for ascertaining of the claim of the dispute also can go to the court. Means there is a default, there is a dispute relating to the ascertainment of the claim. So that can be done even during moratorium. Clause B, transferring, encumbering, alienating or disposing of the corporate debtor, any of its assets or any legal right or beneficial interest therein. For this, exception is interim finance can create. For interim finance to raise can create a security. And next 3, that is clause C, any action to foreclose. Foreclose means foreclose, recover or enforce any security interest created by the corporate debtor in respect of its property, including any action under the surface. The recovery of any property by the owner or lessor where such property is occupied by or on in the possession of the corporate debtor. Means if still tenancy or lease or whatever is not completed, he cannot recover, but naturally the lease has been terminated, then can owner ask for possession of the property. It is hereby clarified that notwithstanding anything contained in any other for the time being in force, a license, permit, registration, quota, concession, clearance or similar grant or right given by the CG, SG, local authority, secretarial, regulator, any other constituted under any other law for the time shall not be suspended or terminated on the ground of insolvency, subject to the condition that there is no default in the payment of current due arising for the use of continuation or license or similar grant or right during moratorium period. Means if any license has been granted by any authority, they cannot cancel that license because of cancelling the business may go still more losses, so they cannot cancel the license or whatever during the moratorium period. But company should pay for license for one suppose for license we have to pay the renewal. If renewal not paid, then the authorities can take action whatever they want. But if all the dues and all related to renewal and all company is making, then they cannot cancel the license on the ground that the company is into liquidation or insolvency and all. Till the completion, they cannot enforce anything against the company. They have to not cancel the license or anything given. Only if company made the default, then they can, as per the contract they entered into. The supply of essential goods or services to corporate debtor as may be specified shall not be terminated. Even supply of essential also shall not be terminated during the moratorium. Where IRP or RP as the case may be, consider supply of goods services are critical to protect and preserve the value of the corporate debtor and manage the operations of such corporate debtor as a going concern. So, these are supply of goods is important to manage company as a going concern. Then the supply of goods shall not be terminated, suspended. Normally they cannot, but if corporate debtor not paid the dues, then they can stop the supply. If corporate debtor doing good, only on the reason that CRP has been initiated, they cannot stop the supplying of goods and services. Next, the provision of section 1, that is moratorium will not apply to first such transaction, agreement or arrangement as notified by the CG in consultation with any financial regulator or authority. So CG said keep this transaction out of moratorium, then allowed. And surety in a contract of guarantee to corporate debtor, surety is also out of the moratorium. The order of moratorium shall have the effect of from the date of order till the completion of the CRP, provided that where at any time during CRP, if the AA approves the resolution plan or passes an order of liquidation, the moratorium shall cease to have effect from the date of such approval or liquidation as the case may be. Prohibition of certain act. On ICD, that is insolvency commencement date, the NCLT shall order declare moratorium for prohibiting certain act laid down under the code. Ensures that corporate debtor retains its going concern status by protecting the corporate debtor from suspension, termination of the licenses and all. And however, if corporate debtor does not make the defaults only. If they make default, they can cancel. Supply of essential certain goods and services during the insolvency resolution process may be important for ensuring the orderly completion of proceedings. However, cost for such goods or services will have to be paid in priority to other costs as a part of resolution plan or during distribution of assets in case corporate debtor goes into liquidation. If they goes into liquidation, first they have to give priority to payment of supply of essential or services and exclusion of certain act. Same thing already done, repeated. And what is essential goods and services is given in regulation 32 of IBPI. First, electricity, water, telecommunication services, information technology services, to the extent there is not a direct input to the output produced or supplied by the corporate debtor. Effect of order of moratorium. The order of moratorium shall have effect from the date of such order till the completion of the CRP, provided that where at any time during the CRP process, if NCLT approves the resolution plan under or passes an order for liquidation, the moratorium shall cease to have effect from the date of such approval. And next, what is ICD? Insolvency commencement date means the date on which admission of an application for initiating insolvency resolution process by adjudicating authority under 7, 9, 10. Moratorium will continue to in effect till the completion of CRP or approval of resolution plan or passing of order of adjudicating authority for liquidation. Either of this, whichever is earlier. Declaration of moratoriums of the following. First, this is a repetition only. Public announcements of CRP. Section 50 lists out the particulars that a PA of initiation of CRP for the corporate debtor shall contain. This section provides the PA of CRP shall contain the following info. Name and address of the corporate debtor under CRP, name of the authority with which the corporate debtor is incorporated or registered, last date for submission of the claims, details of the interim resolution professional who has vested with management of the corporate debtor and be responsible for receiving claim, penalty for false or misleading claims, date on which the corporate CRP shall close, which shall be the 180th day from date of admission. Appointment and tenure of IRP. Section 16 provides for appointment and tenure by the AA. This section reads, the AA shall appoint the IRP on the ICD where the application for CRP is made by the FC or CD, as the case may be. The RP as proposed respectively in the application 7 or 10 shall be appointed as IRP if no disciplinary actions are pending against him. Where application for CRP is made by the OC, and there are two chances. First, no proposal of IRP, then adjudicating authority shall make reference to the board, that is IBBI, for recommendation of an insolvency professional who may act as IRP, and a proposal for an IRP is made. If made by the OC, the resolution professional as proposed shall be appointed as IRP if no disciplinary proceedings are pending. The board shall within 10 days of a receipt of reference from the AA under subclause 3A recommend the name of the IP to AA against whom no disciplinary action is pending, and the term of IRP shall continue till the date of appointment of IRP. Appointment of IRP. Section 16 provides that NCLT shall appoint an IRP on the ICD. This ensures that there is no delay in the IRP and the corporate debtor is managed by the IRP from the first day itself, leaving no room for the promoters or directors of the corporate debtor to take any fraudulent or wrong step with regard to business of the corporate debtor during the insolvency period. 16.2 provides where the application for CRP is made by the financial creditor or OC and the name of resolution professional is proposed, then such person shall be appointed as IRP provided no disciplinary action pending against him. 63 provides that where the CRP initiated by OC and OC proposes name, the AA shall appoint professional as the IRP if no pending. Same thing repeating. 16.3 provides that name is not proposed by the OC, then make reference to the IBBA and IBBA will recommend whom it's a criteria. Tenure of IRP till the date of appointment of RP. This ensure that the business and dealings of the corporate debtor is always under the supervision of IRP or RP. Management of affairs of corporate debtor by IRP. Section 17.1 Code provides that from the date of appointment of IRP on the insolvency commencement date, the management of office of the corporate debtor shall vest in the IRP the powers of the board of directors of the partners or the partners of the corporate debtor as the case may be shall stand suspended and exercised by the IRP. The officers, managers of the corporate debtor shall report to the IRP and provide access to such documents, records of the corporate debtor as may be required by the IRP. The financial institution maintaining accounts of the corporate debtor shall act on the instructions of IRP in relation to such accounts and furnish all the information relating to corporate debtor available them to the IRP. 17.2. Code further provides that IRP vested with the management of the corporate debtor shall act. This is the duty of IRP. Act and execute in the name and on behalf of the corporate debtor all deeds, receipts and documents. Take such actions in the manner and subject to restrictions as may be specified by board, that is IBBI. Have the authority to access the electronic records of the corporate debtor from IU having financial information of corporate debtor. Have the authority to access the books of accounts, records and other relevant docs of the corporate debtor available with the government authorities. Be responsible for complying with requirements under any law for the time being in force. The section 17 lists out various powers that IRP shall have, including the power to do all act, execute in the name of corporate debtor. These powers are important for effective discharge of his responsibilities. Section 17 has been inserted keeping in mind that experience of debtor in possession regime under the SICA. Various committees report which has analyzed the provisions of SICA had highlighted that debtor in possession regime as one of the fatal flaws. So debtor in possession regime, which allows the existing management to remain in the possession during the resolution process, gives incentive to management to propose and implement risky rescue measures as the cost of failure would largely borne by creditors. So SICA now stands repealed with effect from 1st December 2016 and the SICA Repeal Act 2003 has been notified by government. And I forgot to mention in moratorium related, there was a case MS Subhashree Realty Private Limited versus Mr. N. Subharao and others. So once the moratorium has been declared, the officers, directors and whoever persons employing in the company, they will not be thrown out of the organization. The functions and duty what they are doing in the company, they has to do under the after receiving the instruction from the RP, they have to do. If they are not doing even after IRP saying, then they may be removed by giving the notice from that power or position. The IRP shall perform the following duties, namely to collect all info relating to assets, finance, operations of the corporate debtor, for determining the financial position of the corporate debtor, including information relating to business operations, financial and operational payments, list of assets and liabilities, such other as may be specified. Receive and collect all the claims submitted by creditors pursuant to the public announcement. Constitute a COC. Monitor the assets of the corporate debtor and manage its operations until a RP is appointed by the COC. File the information collected with the IU. Take control and custody of any asset over which corporate debtor has ownership as rights as recorded in the balance sheet of the corporate debtor or with VIU or depository of the securities or any other registry that records the ownership of the asset, including asset over which corporate debtor has ownership right, which may be located in foreign country, assets that may or may not be in the possession of corporate debtor, tangible assets whether movable or immovable, tangible assets including intellectual property, so tangible, intangible and possession of the corporate debtor and foreign country, and fifth, securities including shares held in any subsidiary of the corporate debtor, financial instruments, insurance policies, assets subject to determination of the ownership by a court, or means asset in the dispute. This was the exception also in the moratorium to perform such other duties as may be specified by the board. Section 18 also specifies the assets that cannot be taken over under the said section. The explanation appended section 18 provides that for the purpose of this section, the term assets shall not include the following. First, assets owned by third party and in the held in the trust. Assets owned by the third party but are in the possession of a corporate debtor, held as a trust or under contractual arrangements including the bailment. So corporate debtor is holding any asset as a trust or bailment. So owner is third party. Assets of an Indian or foreign subsidiary. So subsidiary will not come, and such other assets as may be notified by the CG in consultation with any financial sector regulator. RP is not only required to give notice of the meeting to members of the COC but also to the members of the suspended board of directors or partners. So he has to give RP is not only required to notice to members of COC but also to members of suspended board of directors or partners. So for all he has to give notice. The OC or the representative are also to be informed and attend the meeting of COC if the amount of aggregate due is not less than 10% of the debt. Case law Miss Innovative can be used for section 17 and Canara Bank can be used for section 18. Next, section 19. 19 imposes an obligation on the personal, promoter, any other person associated with the management of the corporate debtor to extend all assistance and cooperation required by the IRP in the management of affairs of the company. Where the personnel of the corporate debtor, promoter, any other person required to cooperate with the IRP do not extend the cooperation or assistance to the IRP, the IRP may apply to the adjudicating authority for an order. The AA may by an order direct the person to comply with the instruction of IRP or to provide information to the IRP. Personnel includes the director, manager, KMP, designated partner and employees if any of corporate debtor. Personnel, promoters or any other person associated with the management. The personnel of the corporate debtor, its promoters, any other person associated with the management of the corporate debtor shall extend is all assistance and cooperation to IRP as may be required in managing the affairs. Application same repeated. Assistance and cooperation by personnel deals with the assistance cooperation of the corporate debtor. It states that IRP or RP as the case may be shall take custody and control of all the specified under this regulation from the personnel of the corporate debtor, its promoters or any other person associated with the management as the case may be of the following: records of the information relating to assets, finance, operations of the corporate debtor and the assets recorded in the balance sheet of the corporate debtor. The personnel of the corporate shall provide to IRP or RP a list of assets and records while handing over their custody and control, and the IRP or RP, after taking such custody and control if deemed necessary, who is in possession, the assets will be held, record will be held. Where any asset or record has not handed over or the list has not provided, the IRP or RP as the case may be shall himself prepare a list of the assets and records while taking custody and control of the assets and records. IRP or RP may, after taking custody and control, if deemed necessary, identify person in whose possession these assets and records will be held. Each list of assets and record shall be signed by the parties present and there at least two individuals who have witnessed the act of taking control and custody of such assets and records. The IRP or RP as the case may be shall requisition from the personnel of the corporate debtor the information relating to assets, finance, operations, corporate debtor which were required to be maintained by the corporate debtor but have not been handed over. When some of the assets were not handed over, the list of the things which have not handed over. So two lists which have handed over, that one list, and which have not handed over, that list also will be prepared. The IRP or RP shall request from the personnel of the corporate debtor the assets which are recorded in the balance sheet and in any other records and whose custody has not been handed over. An application made under 19 subclause 2 in respect of failure to provide any asset or record as requested by the code and this regulation shall show presence of such asset or record in the notice of request and absence of such asset or record in the list of assets, the records taken in the control and custody. Section 20. Management of operations of corporate debtor as going concern. The IRP shall make an endeavor to protect and preserve the value of the property of the corporate debtor and manage the operations of the corporate debtor as a going concern. For the purpose of IRP shall have the authority to appoint accounts, legal or other professional, to enter into contracts, first to appoint, next to contract, next to raise interim finance and next to issue the instructions and last to take all the actions. So appoint the accounts, legal or other professional to enter into contracts on behalf of the corporate debtor or to amend or modify the contract or transactions, to raise the interim finance provided that no security interest shall be created over any encumbered property of the corporate debtor without the prior consent of the creditors whose debt is secured over such encumbered property, provided that no prior consent of the creditor shall be required where the value of such property is not less than the amount equivalent to twice the amount of the debt. Means if debt is 1 lakh, he want to raise the finance 50,000 and secure the 1 lakh asset for that 50,000 loan. So he can to issue instruction to personnel of the corporate debtor as may be necessary for keeping the corporate debtor as a going concern, to take all the actions as necessary to keep the corporate debtor as a going concern. Instruction and action as required to going concern. Manager of operations of corporate debtor as a going concern, the IRP shall make every endeavor to protect and preserve the value of property of the corporate debtor and manage the operations of the corporate debtor as a going concern. Authority of IRP in order to protect and preserve the value of the property of the corporate debtor and manage the operations of the corporate debtor as a going concern, the IRP professional shall have the authority to undertake certain actions prescribed by the code. Interim finance. The IRP has the power to raise the interim finance as well as enter into, amend or modify contracts on behalf of the corporate debtor, and also shall have the authority to raise interim finance provided that no security interest shall be created over encumbered property of the corporate debtor. Shall not create on encumbered means the property which is not encumbered on that can create a security without the prior consent of the creditors whose debt is secured over such encumbered property. If we want to create a security on encumbered property, prior permission of the concerned security creditor is required. And proviso is that no prior consent of the creditor shall be required where the value of such property is not less than the twice the amount of the debt. If property value is twice than the amount raised. Section 20 Code makes provision for raising of interim finance while managing the operations of the corporate debtor as a going concern. A company which enters into IRP finds it extremely difficult to obtain credit, as the lenders are often hesitate to lend to a troubled debtor. In order to address this issue, such interim finance is treated as a part of IRP cost and is repaid in the priority to other debt as a part of resolution plan. Such priority also applies in distribution of asset in case the corporate debtor goes into liquidation. Next, appointment of RP. One of the main function of COC is to appoint the RP under section 21 of the code. Section 22 provides for appointment and of IRP, provides that at the first meeting of COC, which is held within 7 days of its constitution, the COC by a majority vote of not less than 66% of the voting share of the FC may either resolve to appoint the IRP as a RP or replace the IRP by another RP. Communication of the decision. According to clause A of 22, where the committee of creditors resolve to continue the IRP as RP, it shall communicate its decision to the IRP, the corporate debtor, and adjudicating authority. The appointment of IRP as RP will be subject to a written consent from the IRP in the specified form. Application before AA. In case if the committee of creditors resolve to replace the IRP, the RP shall file an application before AA for the appointment of the proposed RP along with the written consent from the proposed RP in the specified form. Confirmation by IBBI. The AA shall forward the name of the RP proposed to the board for its confirmation and shall make appointment after confirmation by the board. So IBBI will make a reference of so and so as a RP and appointment will be done by NCLT. If board does not confirm the name of the proposed RP within 10 days of the receipt of the name proposed RP, the AA shall by the order direct the IRP to continue the function as the RP until such time the board confirms the appointment of proposed RP. Eligibility for RP. Regulation 3 of IBBI for corporate regulation based on the following eligibility criteria for a RP. An insolvency professional shall be eligible to be appointed as a RP for a CIRP of a corporate debtor if he and all the partners and all the directors of a insolvency professional firm or entity of which he is a partner or director are independent of the corporate debtor. So, the firm should not anywhere connected to the corporate debtor. Firm and its persons also should not be connected. A person shall be considered independent of the corporate debtor if he is eligible to be appointed as an ID independent director and is not a related party of the corporate debtor and is not an employee or proprietor or partner of a firm of auditors or secretarial auditor in practice, or cost auditor, or of a legal or consulting firm that has or had any transaction with the corporate debtor amounting to 5% or more of the gross turnover. So in the last 3 financial year, first one is firm and all should not be, and second one is legal way for and 10% 5% of the gross turnover of such firm comes from the corporate debtor. Here they are also not eligible. Where the COC decides to appoint IRP as RP or replace the IRP under section 22 or replace the RP under section 27, it shall obtain a written consent. An IRP or RP shall make a disclosure at the time of his appointment thereafter with the code of conduct. And third, an IRP or RP who is a director or a partner of a firm shall not continue as a resolution professional in a CIRP if the insolvency professional entity or any other partner or director of such insolvency professional entity represent any of the other stakeholders in same corporate insolvency resolution process. So they are now representing any stakeholder, so then also they cannot, and they are the director or a partner of an entity. RP to conduct CIRP. So section 23 provides that RP shall be responsible for carrying out the entire CIRP and manage the operations of the corporate data during such process. For this purpose, RP shall exercise powers and perform duties as are vested or conferred on interim resolution professional under Chapter 2, Part 2. Section 23 also provides where RP is appointed by the AA upon the confirmation of the board, the IRP shall provide all the information. So IRP should provide all the information, documents and records pertaining to the corporate debtor in possession and knowledge to the resolution professional. So before IRP will be dealt with the process, so he have to submit all the documents to new RP. Section 23 of the code as follows. Subject to section 27, the RP shall conduct the entire CIRP and manage the operations of the corporate debtor during the CIRP process. Provided that RP shall continue to manage the operations of the corporate debtor after the expiry of the CIRP until an order approving the resolution plan or appointing a liquidator is passed by the adjudicating authority. So even if the resolution plan not got approved and went into liquidation, so till the time liquidator has to appointed, till then he has to continue not only in the CRP process but also till liquidator gets appointed. RP shall exercise powers and perform the duties as are vested or confirmed by the IRP under the chapter. In case any appointment of RP, the IRP shall provide same repeated. Here in the box they gave IBC code amendment ordinance amend, provide that RP shall continue till to manage the operation expiry, same point. Passed by the A, this amendment clarifies that managing the affairs of the corporate debtor during the period between conclusion of the CIRP and implementation of the successful RP resolution plan or commencement of the liquidation shall be the responsibility of the RP. So they gave clarity, it is the responsibility of the RP till even after the CIRP has stopped, he has to continue. Section 25 set out the duty of the resolution professional to preserve and protect the assets, to preserve and protect the assets of the corporate debtor, including the continued business operations. So he has to preserve the asset and continue the business operations as well, and lays down the functions he may perform for the same. 25(2) provides that in order to preserve and protect the assets of the corporate debtor, including the continued business operations of the corporate debtor, the resolution professional shall undertake: first, take immediate custody and control of all the assets and represent and act on behalf of the corporate debtor, represent and act on behalf of the corporate debtor with the third party, exercise rights for the benefit of the corporate debtor in quasi-judicial bodies, raise interim finance subject to the approval of committee of creditors, appoint accountants, legal professionals and others, maintain an updated list of the claims, convene and attend all the meetings of the COC, prepare the information memorandum in accordance with the section 29. invite prospective resolution applicant who fulfill the such criteria as may be laid down by him with the approval of committee of creditors having regard to complexity and scale of the operations of the business of corporate debtor and such other conditions as may be specified. Present all the resolution plan at the meetings of the committee of creditors. File application for avoidance of transaction in accordance with the Chapter 3, such other actions as may be specified by the board. The RP is also empowered to raise interim finance, whether secured or unsecured, with the prior approval of the COC. The interim finance raised under this section will also be the covered as cost of the CRP cost.